Welcome to week 6 of our Right versus Might in International Relations MOOC. Welcome to all our regular viewers for these Hangouts and to the regular discussants in the fora. And welcome also to those who've joined this for the first time as a Google Hangout session. My name is Christian Tums. I'm Professor of International Law at the University of Glasgow, and I was the lead educator for this week's session on investment law. Now, week 6 was the final week of our MOOC, and in some ways it was a special week. It was probably an exciting and challenging week too. We have been discussing a topic that is challenging for all intents and purposes, investment law. And of course, it's a topic into which where sort of opinions are clearly divided. That was very clear from the group discussions. It's a topic that is sometimes perceived as technical, and I think some of our main interest has been in making sure that you see that there's behind the technical issues, there's a lot of political relevance hidden. And of course, it was also more pragmatically a challenging week because you've been asked to do a peer-reviewed exercise, and many of you have done that. So congratulations on making your way through this challenging week. Congratulations especially on those who've participated in the debates and enriched our discussions. And a particular word of congratulations to those who've completed the peer review assignment. Now, before I discuss the real topic of the Hangout, which was the Transatlantic Trade and Investment Partnership, referred to as TTIP, which is so much discussed at the moment, let me say a few words about the choice of the topic, the reasons that motivated us to choose this topic for the last of our weeks in this MOOC. Now, investment law, compared to the topics of the other weeks, in some ways was the odd one out. It's not investment law, a topic that you obviously link to questions of security, to the major questions of peace and war, even though historically questions of investment dispute have triggered wars and conflict. So it was the odd one out, but I hope you'll agree with me that we chose well in selecting this for coverage. Why is it relevant? Well, I think it's relevant because the stakes are just so high. If we're thinking about security in the 21st century, we cannot only think of war and peace in the military sense. Nations' fates depend on financial matters, and we've seen that very clearly in the past few years. And investment law plays a relevant role in this. It is not only a highly sophisticated area of law and a highly controversial one, but it's also one that cannot be completely dissociated from questions of international security in the traditional sense. So I hope you'll agree that it was a wise choice. I was glad to read that some of you expressly said so in their comments and thought it was a fitting ending. It was certainly fitting in terms of the timing, because there could hardly have been a better way to discuss investment law than this one. This week, as those of you who participated in the discussion knows, and those of you who read the newspaper probably also know, this week in some ways was a momentous one for international investment law. Midweek, an arbitral tribunal sat in The Hague, which was not one administered under the ICSID Convention, about which you've read a lot, but under other sets of arbitral rules, but still an investment arbitral tribunal rendered what has been the highest compensation award of all times. An arbitration award rendered for the benefit of companies that take up claims brought on behalf of UCOS. It was not UCOS as such. Companies have borne different names, but let's refer to it as the UCOS award against Russia. And Russia was ordered to pay the staggering sum of $50 billion in compensation for its treatment of the UCOS company about a decade ago. Now, $50 billion, if you want more information or if you want evidence that investment law is relevant, then simply reflect on that sum, $50 billion as a compensation award. If you want evidence that investment law cannot be dissociated from questions of high politics and security, just simply reflect on the impact of such an award on the current geopolitical tensions between Western states and Russia. Just imagine what, depending on your perspective, an added complicating factor this is, or a godsend for those who want to put pressure on Russia. Now, I'm not naive and suggest that this award will be easily enforced and that this award will change everything immediately, but simply, the timing could hardly have been more fitting to bring out that investment law matters. It is part of the big issues, and awards by arbitral tribunals play a major role. Now, this week was also the odd one out, or mainly the odd one out, of course, because investment law is different, and that too is brought out by the UCAS award. It is different from the other areas of international law that we have been looking at over the past 6 weeks. It's different in many respects, and I'll single out three. The first is that investment law is not state-to-state law. It is created by states, but the main actors in the process are a state and an investor, and typically in reverse order. An investor by instituting proceedings against a foreign state. This is unusual. This is not unheard of. We have similar settings in other areas of international law, and notably in human rights law, where we have a non-state actor that is involved in a process and a state which responds to allegations. But it's pretty unusual compared to the other areas of law that we've been looking at, where we've discussed, for example, the use of force between states. So this is one aspect in which investment law is different. The second point is perhaps more relevant, and it's one that I'll come back to throughout the whole sort of duration of this Hangout session, because it's a point I want to emphasize. So unlike in other areas of international law, in investment law, we're having to deal not exclusively, but to a large extent, with dispute resolution between investors and states before international tribunals. The UCAS award was rendered by an arbitral tribunal. The Vattenfall award will be rendered by an arbitral tribunal. The tribunal is not a court, and again, I'll come back to that point because it was emphasized in the discussions, but it is a body that is competent to come to a binding decision. This makes investment law an unusual part of international law, because in the other areas of law that we've looked at, we've mostly discussed international law in the absence, out of court. We've heard about the Security Council. We've heard about possibly domestic courts. We've heard about diplomatic tensions. But the idea that a dispute, a legal dispute, would be submitted for binding decision to a court or a tribunal was not the norm. And on the face of it, this makes investment law not only different, but probably quite advanced. It's quite an advanced area of international law, where if you feel your rights are being violated, you have access to a court and a tribunal. Now, that is getting lost, and perhaps it's rightly getting lost, sometimes amid the criticism about investment law. Perhaps investment law is the wrong system, perhaps going to court or going to a tribunal is the wrong way of settling disputes. But I think at the outset it's important to note that from a broader general international law perspective, it's unusual and it's more advanced than the dispute settlement process in other areas. Not necessarily the right way, but a way of settling disputes that otherwise we would be quite keen on having. Wouldn't it be interesting if, let's say, the current dispute about the territorial status of Crimea could be submitted to a court for dispute resolution? Wouldn't it be good if a court ruled on claims by Israelis and Palestinians about what is right and what is wrong? In other areas of international law, we deeply lack courts and tribunals. In investment law, we perhaps have rather too much of them. That is the second reason why investment law is unusual. And the final point that's related is that investment law is unusual because it doesn't fit our easy views on right versus might in international relations. And that's a point that was made by a few of you and quite perceptively in the comments. Michael Hartmann and Peter Johnson in particular, I've noted that down, made that point repeatedly. Again, take human rights. for human rights, the emotional setting is always clear. We have poor human individuals whose rights are being trampled on by evil states, and international law is one of their hopes that they cling to. So right is represented by international law, and it saves you or protects you, or hopefully gives you a bit of a hope of protection against the might represented by non-international law. Now that easy and of course cliched view of international law as a shield of protection, right versus might, doesn't work all the time. Think back to an earlier case study on Guantanamo, where we could discuss whether international law really was right versus might, or whether it didn't help to institutionalize and stabilize a situation of power politics. But it particularly troubles us in relation to investment law. And this is what some of you noted in their comments. Is investment law an area where the rule of law is observed regularly? Is investment law the right way of going about it? Or is it a system that benefits, as some of you seem to suggest in their comments, evil corporate might? Or is it maybe a bit of both? Michael Hartman in his comments gave a good example. Would we be thinking differently about the Vattenfall dispute if this wasn't a nuclear energy company, but an eco energy company that took Germany, in a hypothetical setting, to court because Germany had decided to pull out of renewable energies? Would we be thinking about this differently then? Would we then think of investment law as protecting poor eco-friendly companies against state might? But we needn't even go to the hypotheticals. Think to the UCOS award. If we're unhappy about the Vattenfall versus Germany setting, where, as some of you suggest in your comments, an evil company benefits from a biased system, then does the same apply to the UCOS award? Or would we rather look to UCOS and the award more favorably as an opportunity, at least, to scrutinize state behavior, even where we may not all be fans of UCOS, and UCOS is quite a mile away from sort of a small startup engaged in renewable energy. So 3 reasons why investment law is different from the other areas, and I think why it's exciting. At least I feel very strongly that it's exciting. It's relevant, and it also is ambivalent. It's not easy to be coming out clearly one way or the other about investment law. Now, finally, the other reason, of course, we wanted to discuss investment law and why we think it's crucial to discuss it is that it's so topical. And this brings me to the topic, the real topic of today's Hangout session. That's the negotiations about TTIP, the Transatlantic Trade and Investment Partnership. Now, as is clear from the comments, you followed this and engaged with that debate, whether because of this Hangout, because of this week 6, or because of your general interests, in a very active way. And it was highly instructive to read your comments. I think we've all benefited from them. Now, TTIP is being negotiated now. The process has been ongoing for a while, but it's nowhere near complete. So this is an ongoing process, just as the Vattenfall case was an ongoing case. And in that respect, TTIP is quite a typical case, because investment law is constantly being negotiated. As you will have read, and as some of you have pointed out, it's not based on a multilateral treaty that was negotiated at one point and then stands, like the UN Charter, for example. Investment law, substantive investment law, is based on bilateral or regional treaties, of which there are thousands, and of which new ones are added all the time. Now, that is in some ways a very cumbersome process of going about laying down the law. It is also a process that allows changes in perception about investment law to be reflected more quickly. Where the UN Charter is negotiated, it takes quite a dramatic amount of political will to change it. With investment law, changes in perception about investment law can be reflected in the treaties that are being negotiated. And TTIP, as it's being negotiated, reflects the current, or will reflect the current thinking, if it is going to be concluded at all. Your comments about TTIP clearly reflect diverse views and also diverse issues that are raised with respect to TTIP, the Trade and Investment Pact. Not all of them, I have to say at the start, are matters of investment law properly so-called. Some of you are worried about genetically modified foods. Some asked about farming subsidies. Now, those would be relevant matters, and those are matters that are validly there for public concern, but those would not typically be questions that would be addressed in the investment law chapters of the TTIP. There will be special chapters on trade liberalization, on subsidies, on the agricultural sector, etc., which are highly important, but which I will leave to the side here today, with apologies to those like Mary Hawking or Sinya Jayasundra who raised those matters, which I will leave to the side here because they are not really conducive to being addressed within the investment law framework. Investment law is one, if only one, if a very controversial part of TTIP. It's for obvious reasons called the Trade and Investment Partnership, and the bulk of it concerns trade regulation, including questions such as access to markets, subsidies, etc. Now, if we focus on the investment law questions raised by TTIP, then there's still quite a lot for us to cover, and two things currently stand out, two things on which I'll focus, and on which precisely the diverse and often critical views that you expressed in the comments are reflected in the public and in the expert debate. In fact, in the governmental debate. So the points you were raising are precisely the points that lawmakers from Europe and from the US are raising in discussions with the treaty negotiators. Ask the current European commissioners who are involved in the negotiations. They are being asked precisely the questions that you raised. So the two things that I think are the most important ones, or the two questions that I think are the most prominent ones at the moment, is should there be at all a TTIP agreement on trade and investment liberalization between the EU and the US? And the second one, if there will be an agreement on trade and investment between the US and the EU, how will that agreement strike the balance between the two competing interests that we've been talking about, the interest of public interest of the state to be able to regulate, and the right of investors to be free from improper interference with their rights by states. I'll organize my comments according to those lines. And I'll talk first about whether TTIP at all should be concluded, and whether it should at all include a chapter on investment protection. I think, as I've said a minute ago, investment law wasn't the impetus for having those trade and investment negotiations. Most today would say that if TTIP has a tangible positive benefit on economic development, then mostly through trade liberalization and restriction of trade regulation between the two entities on the two sides of the Atlantic. So these would be issues of sort of harmonization, of reducing red tape, of opening up access to markets in trade, mostly of reducing tariff and non-tariff barriers to trade, on restricting the potential for states to discriminate between goods that enter the market and potentially even services. All those matters are related to the economy, just as investment protection is, but they are subject to separate disciplines. I'm not an economist, but it seems to me that those would be the benefits that could potentially flow from a trade pact between the US and the EU. Now, it's clear from the list of issues I've mentioned that you don't need to be in favor of that. It may indeed be that TTIP will add further to the worries of European states in banning genetically modified food. It may be indeed that TTIP will put pressure on European states keen on protecting public services from market forces, on having something like, and every country has its own sort of big topic there. It may be a question of sort of cultural exceptions to free trade, a traditional French concern. It may be a question of restricting and limiting and regulating the price for books to be sold, a traditional German concern. It may be shielding certain segments of the market from free market competition. So competition law may be an issue. So trade liberalization outside investment law comes at a price, and it's by no means a given that this would be a good thing. But as I said, it's a slightly separate debate from the one on investment protection. As for investment protection, from relatively early on, while not the key motivating factor, investment protection was meant to be included in the Trade and Investment Pact between the EU and the US. But it has now become particularly controversial, partly because of dispute resolution, the idea of investment arbitration, about which I'll speak in a minute, but partly also because many people ask exactly the same questions that you have been asking in the comments. Why should foreign investors be privileged? Is there a need? I think Peter Johnson made that point. Is there a need to have protection over and above the protection offered by domestic law, or in the European context, EU law, for foreign investors? Why should foreign investors be privileged over domestic investors? Remember, in the Vattenfall scenario, Vattenfall enjoys more protection than German energy companies because it's foreign. That's completely different from international law elsewhere, which, I mean, ask refugee lawyers or refugee advocates. The best they can ever hope for is non-discrimination, treatment for refugees like nationals. In investment law, the opposite is true. Foreign companies have potentially more rights than domestic companies. And of course, that in itself is by no means generally acceptable. Questions can be asked, do we need that? And in particular, and I think that's the point that was made in comments, in relation between the EU and the US, can we not trust the domestic legal orders? So maybe the added advantage of adding a chapter on investment protection isn't so great compared to investment agreements of old, or perhaps even compared to investment agreements that are negotiated, for example, at the moment between China and the EU. So there's a big argument, and this concludes my comment on the first point, should there be TTIP at all with an investment chapter? There's in fact quite an argument that given that investment law causes so much controversy, TTIP should be concluded without an investment chapter. The rest should be rescued, if you want, and an investment law, or the investment chapter, would be a price, or giving up the investment chapter would be a price worth paying for having the rest of TTIP. That is a potential outcome. As some of you have mentioned, and I'm sort of singling out Colin Huckabee here, a million issues, or I think your term was 1,000 issues. Well, a million or 1,000 issues remain, and it's by no means clear that agreement on even a TTIP minus investment would be reached, whether in the US or in the EU. On both sides, it's a horribly complicated setting. In the EU, most likely there will need to be some sort of at least positive vote from all the EU member states. In the US, it's still by no means clear how Congress will deal with the mandate for this international treaty. Of course, we needn't be overly optimistic, even whether something like TTIP without investment law will be agreed anytime soon. It seems less and less likely. But I think it's fair to say, in the range of issues that TTIP will cover, investment law is a particularly controversial one. And I think it's to that controversial segment of TTIP that I'll turn now. If there will be a TTIP agreement, and if it will have an investment protection chapter, what should this look like, or what will this look like? Of course, in some ways we need to speculate because we don't know the final text. But I think one thing is fairly clear, and this in some ways goes against some of the points made in the discussion, or I would say in order to have you reflect on a further issue, I think it seems very clear that if there will be investment protection in TTIP, it will be a different version of investment protection different from the one that is, for example, written into the Energy Charter Treaty, which applies to the Vattenfall dispute, or different to the type of investment protection that investors benefit from under old investment agreements. I'm not trying to convince you that TTIP is a great thing. I think that's a point on which not only reasonable, but all sorts of people can have widely diverging views. But I think I want to emphasize one point, and that is that TTIP will, if it comes with an investment chapter, have a modern investment chapter that avoids some of the pitfalls of that you've been rightly critical of. Perhaps not all the problems, and as I said, I'm not saying to you that we should all have it, but in the interest of an informed debate, I think we must get over some of the cliches that are being sort of talked about in some of the literature. So 2 points I will make with respect to this. The first concerns the substance of investment protection, if it ever features in the TTIP agreement. And with substantive investment protection, I mean the standards that you've been reading about in the past days, the standards with these curious acronyms, FET, MFN, indirect expropriation as well, national treatment, etc., etc. I think it is a very clear, or it's a very safe bet that if TTIP will have an investment chapter, the standards of investment protection of that investment chapter will be more nuanced than some of these sort of very general, very open-ended standards that you could find in old treaties. And why is that so? I mean, the reason for this is obvious. Governments are not made up of idiots. Government officials know what investment law can do to them, and government officials in countries like Germany are not happy about the fact that they need to defend themselves against a claimant like Vattenfall. They will make that experience once, and then when a new treaty opportunity comes up, they will have that in the back of their minds. The same is true for the US. The US has had a couple of investment arbitrations brought against them in the context of the North American Free Trade Agreement, NAFTA. And since those arbitration proceedings, they have taken a different approach to investment protection. We can simplify this a bit, but I think we would still be sort of on safe grounds if we said Western states were very keen to have maximum investment protection as long as they felt this benefited their investors going abroad. Then you would always insist on investment protection against the pitfalls or the uncertainties of domestic law regulation. For a decade or for 15 years now, investors have brought proceedings against Western states. And Western states have realized that investment protection, contrary to their initial expectation, is not a one-way street. And this is reflected in the discussions about the scope of investment protection. So nowadays, states like the US, like Canada, like Australia, like Germany for that matter, like France, like the EU, well, not states like the EU, but entities like the EU are aware of this. And they're very consciously interested in reaching a more balanced level of investment protection. I will take one example only, indirect expropriation, about which you've seen, or to which you've seen some of the references, which is one of the concerns in the Vattenfall case as well. Now, on the basis of what we know from leaked texts about TTIP, it's very clear that the drafters of the TTIP will try to avoid the problems that states faced under old investment treaties. For example, indirect expropriation under TTIP will be very clearly defined. It will be made very clear that non-discriminatory regulations in the field of health and safety will not, or only very exceptionally, amount to indirect expropriation. States are very clear or insist now on their right to regulate in a much more pronounced way than they did when they drafted investment agreements 20 years ago or 30 years ago. Now, again, to repeat my main point, this doesn't mean that you have to like it. It might still be better not to have investment protection at all. But I think it's very important to note that if TTIP comes, it doesn't copy old investment agreements. The negotiators on both sides of the Atlantic are very well aware that they will want to curb investment rights. They will sort of restrict investor protection a little bit. They will be more pronounced on the right to regulate. This can be seen as hypocritical, and I think with some reason, the idea that as long as investment protection was considered as something benefiting your companies abroad, you were going for maximum protection. Now that you realize that it could hit home, you're much more cautious. There's a lot of hypocrisy, of course, in this. But on the other hand, you can see also lessons learned. And I think for the purposes of TTIP, it's very clear that the scope of investment protection will be more balanced than in some of the older treaties. And the standards of treatment, fair and equitable treatment, FET, most favored nation treatment, and protection against expropriation, they will be defined in a more detailed way to avoid the sort of negative, the potential for negative surprises that states faced under old investment treaties. Now, that is my first point, which goes to the substance of investment protection. And very much the same is true for my second point, which is the biggest question in all this TTIP discussion, and that is the question of investor-state dispute resolution, the question which rightly sort of focused much of your attention in the comments. And the big question really there is, should there at all be investor-state arbitration under TTIP? Again, under all these caveats, if TTIP comes at all, if TTIP has an investment chapter, etc., should this investment chapter then provide for the potential of investor-state arbitration so that companies from Europe and the US, when operating in the other treaty partners' territory, could do what Vattenfall does to Germany, namely bring proceedings if they feel their rights are being violated. Now, that is the big debate. And as you could see from the readings, that is where much of the controversy comes from, because investment arbitration is so controversial, and on the face of it, it seems so one-sided. The massive debate at the moment has left us all guessing. The EU initially was in favor, and I think the US was generally in favor of having investor-state arbitration, because they felt this was part of the investment law mix, if you want. And that's very clearly what I think the reading brought out early on in this week's session. Investment protection is almost defined by the fact that you have access to tribunals that deal with investment disputes. That is the distinctive, or the key distinctive feature of the system. So it would be included, thought the EU and the US initially. That is precisely what has come under so much pressure. Pressure echoed in much of the comments to this week's forum, and pressure, of course, that, or I think concern or controversy that I think we wanted to have you discuss in this week's session. It's by no means clear that this is a wise way forward to use tribunals for settling investment disputes. And you see some quite interesting changes of policy here, and I think none is as interesting or as curious as the change in policy in the German government. Germany has long, or is seen as the inventor of the system of foreign investment protection. Germany was the country that signed the first bilateral investment treaty, and for decades, the German government has signed BITs, bilateral investment treaties, with dozens and dozens of states, and was proud of it. It said it was the country with the most BITs signed, and they all, from the 1960s onwards, they would all contain provision for investor-state dispute settlement. Now, that German government, arch supporter of investor-state dispute resolution, has now changed course and is opting for a much more cautious approach where, according to the German government, which is not conducting these negotiations but consulted on them, TTIP should no longer have a chapter for investor-state dispute settlement. Investment arbitration should not be included. That's a major shift of policy which shows the effects of the public discourse on this matter. Now, on this big question of whether TTIP should have investor-state dispute resolution, on whether the old German position or the new German position should be the one that carries the day, I think there's no right or wrong. And I don't mean for a second to convince you one way or the other. All I want to do is make, I think, 3 points that situate this debate. The first is one that I've made twice now in this short hangout, but I'll make it once more and in a fairly succinct manner, largely referring to what I said at the start. Investment arbitration is central to the system. This is what makes investment arbitration special, for better or worse. So removing investment arbitration is not just leaving out a tiny bit. It means removing a central pillar. That is why investors defend it, or industrial business associations, etc., defend it now very strongly. Of course, it's inconvenient and risky. Of course, it's inconvenient for the German government having to answer to Vattenfall. On the other hand, and this is my main point, it's also something that elsewhere in international law we quite cherish, the idea of binding dispute resolution according to international legal standards. So the debate goes not just to a marginal side aspect of investment law, but the debate about whether TTIP should have investment arbitration goes to the heart of modern investment protection law. The second point is one that is similar to the one I was making with respect to the substantive side of investment protection. If TTIP will have investment protection, this will be investment protection that is very different from the investment protection of old. It will still, under all these conditions, if TTIP is concluded, if there will be an investment chapter, and if that investment chapter has investment arbitration, it will still be based on the idea that investors can sue foreign governments, but the process will be quite different. And again, on that we can be certain. We cannot be certain on many things, and in particular we cannot be certain on whether TTIP will come at all, but if it comes, and if it comes with investment protection, that will be a more nuanced system of investment protection. Many of you rightly criticize that investment protection so far has been fairly intransparent. And I think one of you referenced an article from The Guardian, which speaks of secretive panels of arbitrators who render awards that are then not publicly available, etc., etc. Now, from the leaked text that we've seen, or I've seen, it's very clear that if TTIP comes with an investment protection or investment arbitration section, then this will be a more modern, a less controversial investment protection section. It's very clear from the leaked texts that there will be much more transparency. All awards will be public. All documents submitted in proceedings will have to be made available to the public. Hearings will be public, and there will be potential for hearings to be broadcast. This is not something that parties to future investment proceedings under TTIP will be able to exclude, but in narrowly defined cases of sort of business secrets, etc., etc. So TTIP negotiators are taking a very strong step towards transparency because they realize that the charge of secrecy was something that undermined legitimacy. Again, you don't have to like the system because of that, but I think one of the biggest and most obvious concerns will have been met under TTIP. It will be a much more transparent system of dispute resolution. Second point, similar in focus. If TTIP comes with investment arbitration, then it will be less private. It will not just be the investor suing the state. TTIP will have regular provision for participation of civil society organizations in the form of amicus curiae briefs. You will be able to submit as a civil society organization argument and information to the tribunal, and the tribunal will have to accept that, and then you cannot be sure whether the tribunal will decide in your favor, of course. That comes with courts and tribunals. They tend to reserve for themselves the potential to take the decision, but at least civil society voices will have to be heard through so-called non-party submissions or third-party submissions. This is something that has happened before, and under TTIP this will become a regular feature of investment proceedings. Again, a move towards a bit more of an inclusive system of arbitration, because again, drafters realized that a system that excluded civil society was no longer sustainable. Finally, a A third element in which the investment arbitration process will be reformed is that TTIP investment arbitration, if it comes, will see a greater influence of states over the process. And notably, states will set up a treaty committee that will have the power to interpret treaty standards with binding force, and with binding force for tribunals. And again, you can very clearly see, well, either hypocrisy or lessons learned, depending on your perspective. You can very clearly see, just as in relation to points I made earlier, that states are now adopting a more hands-on approach to investment arbitration. States too are worried about the discretion enjoyed by tribunals. They are worried that tribunals can render inconsistent decisions that go against states. And so they are keen to assert or reassert power over the process, and that they do by establishing in the framework of TTIP a committee which has the power to interpret provisions of the agreement with binding force, and it would bind tribunals. So I think in three respects, TTIP investment arbitration, if it comes, will be different and will have avoided some of the problems that a traditional investment arbitration suffers from. Now, my final point on this, and it's the one that I would repeat throughout, is that it's still not at all sure that this is the way of going about settling disputes. Your different views and diverse views on the matter are reflected in the discussions, and I'd be glad if maybe in the light of my Google Hangout or sort of future readings, you'd continue to engage with that. It's by no means God-given that courts are the best dispute settlers. But I think it's important to note, and this was sort of my focus in the last 5 or 10 minutes, that some lessons have been learned, and TTIP will avoid some of the more obvious mistakes that earlier processes of dispute settlement in investment law have suffered from. Okay, this was my attempt to put sort of some perspective to the debates that you've had over the past few days on investment protection. As I said at the start, it's an area of law that has felt fairly technical for a while, and where people haven't really engaged in. But I think it's extremely healthy that the debate of the last few years, and in particular the last year, has broken down these barriers. I mean, investment law is so obviously relevant for a public debate that it was very puzzling how for decades it was left to the lawyers to start with, and to the government officials in particular. It's right that this is now widely debated. The general point that was made, that international law is much too important to be left to the lawyers, applies to investment law in particular. Investment law is much, much too important to be left to the investment lawyers. So the public debate, while sort of displaying the usual things of sort of excessive dramatization, etc., in some instances, is fundamentally a very healthy thing. It will lead to a more nuanced position on investment law in the long run. And whether that nuanced position is one of reform, where some of the edges are smoothened, such as I was suggesting with respect to the lead text of TTIP, or whether it will lead to wholesale reform in terms of giving up the system, is open to discussion at the moment. That is why it's so exciting. That is also why the debates about TTIP are so relevant, because while this is only one treaty, as some of you were saying, it's the single most relevant investment treaty in terms of GDP, in terms of investors affected. It will have a massive effect on future negotiations, future investment agreements. It's the role model for future treaties, and this is why the debate is important. If I may step out of my MOOC educator role here, if you felt that today's or this week's session had brought you in contact with a new area that you found worthy engaging with, then I would wholeheartedly endorse comments that were made that drew you to sort of certain websites where you can make your views heard, not in the course or in the framework of a MOOC, but in relation to actual decision makers who are involved in TTIP negotiations at the moment. This can be in the form of criticism, or it can be in the form of advocates of reform, or it can be in the form of endorsing the system. The jury is out on whether it's a good system, but it's very clear that you have an opportunity to engage in that public debate at the moment. Unlike, I mean, whereas we've generally tried to select disputes that are high profile, political and topical, I think in this week we have, at least for the Hangout session, we've chosen a dispute that is really live, where you can really make your voice heard. And I would encourage you, not as an academic, but simply as somebody who thinks the matter is important, I would encourage you to do that. This concludes my substantive comments on the 6th week of our MOOC on investment law. I hope I've tried to I've been able to pull together some of the more relevant issues that were being discussed and to provide maybe some context or explanation to what is a pretty frightening area of the law. Okay, I mean, this concludes the last of the Hangouts after the last, or towards the end of the last of our 6 MOOC weeks. It's not the end of the course yet, and it's not. I mean, don't expect sort of a 20-minute summary of the course as a whole now. We will limit this to investment law. You will receive, whether you like it or not, you will receive next week a concluding message in which Robin, Antonios, and myself try to set out some of the broader themes of this course, and which we'll try to sort of step back and reflect on what we have learned, the 3 of us, during those 6 weeks of exciting debates. So, but that, I'll leave that for the concluding message to be sent next week. I would also say that while this course now gradually edges towards its conclusion, it will remain open. The moderation, the Hangouts, etc., will stop, but the course will remain open. You will be still able to read material, and you will be able to go back and reread materials if you've found them interesting, or if you stumble across an issue that makes you reflect back to the old days when you were doing reading on counter-piracy or Guantanamo Bay. Then the course will remain open and the materials will remain accessible. So it's not the end. It's not the end. I think that's the main message of my last two comments. The other big message is, of course, a word of thanks to all the MOOC team. While this is not the end, it is the last time I'm speaking to you via a Google Hangout, and I would not want to miss out on that opportunity to thank our 3 brilliant student moderators, graduate students, Athene, Pia, and James, who've done, I think, a wonderful job in moderating and at times instigating debate. And I hope you would agree with that. Without them, this would have been a much more difficult course to run. And I would include Susie Houston and John Kerr, who've sort of done a lot of the background work from the University of Glasgow. Finally, and really finally, if you found this an exciting or interesting experience, then of course MOOCs in some ways are teasers. They benefit, I mean, for Robin, Antonios, and myself, this has been an exciting experience to try out something different. This has been an experiment, but of course it's an experiment that draws on what we're doing every day when teaching at university. It's no replacement for university teaching, and it's perhaps a complement to course offerings that we're teaching at our universities, and in particular at Glasgow. If you found this interesting, then have a look at our Glasgow website and see whether you would want to pursue this, whether this is something for you to engage in, whether it's through graduate study, whether it's through looking at websites. Do get in touch if you feel you can engage with us further. We should be glad if you made use of that opportunity. You'll find further information on this in the concluding message that we'll send around next week, including websites that you can consult. For now, let me thank you for your patience and forbearance during this last Hangout. It's been good fun, and it's been an exciting week full of exciting comments. Thank you for participating in them, and do enjoy the rest of the readings and the rest of the course. Bye-bye.